Start. One of the submissions made before the division bench was that the state had wrongly invoked the provisions of sections 17 in bracket 1 and 17 in bracket 4 of the Land Acquisition Act, hereinafter referred to as Act, and the right of objection under section 5 capital A was wrongly dispensed with. Hence the entire acquisition proceedings deserved to be set aside. The petitioners placed reliance on a division bench judgment of this court dated 19.7.2011, passed in writ petition number 17068 of 2009, Harkaran Singh versus State of UP and others, in which judgment the division bench of this court held that invocation of the provisions of sections 17 in bracket 1 and 17 in bracket 4 of the Act was not justified, and relying on the judgment of the apex court in Radhe Shyam versus State of UP reported in bracket 2011 5 Supreme Court cases 533 and judgment of the apex court dated 6.11.2011 in Greater Noida Industrial Development Authority versus Devendra Kumar reported in 2011 in bracket 6 ADJ 480 quashed the notification dated 12.3.2008 and 30.6.2008. Learned Counsel for the state, refuting the submissions of the Learned Counsel for the petitioners, relied on another division bench judgment of this court dated 25.11.2008 in writ petition number 45777 of 2008, Harish Chand and others versus State of UP and others, in which judgment invocation of section 17 in bracket 1 and 17 in bracket 4 was upheld and the writ petition was dismissed, in which same notifications dated 12.3.2008 and 30.6.2008 were under challenge. Para. Faced with large number of writ petitions challenging the land acquisition by farmers of different villages of Greater Noida and noticing two conflicting views expressed by two different division benches on the same notifications, the division bench passed following order on 26.7.2011 para. Against this background, prima facie, we are of the view that a larger bench is required to be formed for the purpose of hearing these matters, not only in respect of the village in question but also for all the acquisition matters in respect of the New Okhla Industrial Development Authority and Greater Noida Industrial Development Authority, for the ends of justice, to reduce the fume and to avoid the multiplicity of the proceedings. Para. In the same order dated 26.7.2011, to protect the interest of the petitioners, the division bench passed following order. Para. Principle of lis pendens will be applicable in these cases. Therefore, whatever steps will be taken by the respondents in the meantime, the same will abide by the result of the writ petitions. Para. Willing petitioners may make applications to the state or the appropriate authority to consider their grievances, and if it is made, the same will be considered carefully upon giving fullest opportunity of hearing to them, if necessary with the assistance of the pleader, by 12th August 2011, and a report to that extent will be placed before the court along with the records of all the acquisition cases on the next date of hearing, that is on 17th August 2011. Applications, if any, for such settlement out of the court are totally optional on the part of the petitioners. Rights, if any of the unwilling petitioners under section 11-A of the act will not be infringed. Para, if the petitioners make such applications for settlement out of the court with the state or the state authority, the same will be considered by them in the line of the Uttar Pradesh land acquisition in bracket determination of compensation and declaration of award by agreement bracket out rules 1997, which is commonly known as Karar Niyamavali 1997 para. It is pertinent to note that several applications have been made either by the respective builders and oblique or purchasers of flats and oblique or the banks for impediment, which have been strongly opposed by the petitioners by saying that they cannot be made parties to these writ petitions, as in the case of land acquisition, the landowners and the requiring bodies, sometime acquiring bodies are the necessary parties and not others. On the part of one of the applicants, it is submitted before this court that as per the rules of this High Court, any aggrieved or affected party can be treated to be intervener in any of the proceedings. Therefore, no one can be restrained from getting opportunity of hearing. In these special circumstances, they are required to be heard. However, at this stage, we do not propose to entertain such applications. Para, the matters will appear on 17th August 2011. Para, let it be placed before the Honorable the Chief Justice oblique Honorable Senior Judge as per the rules and practice of this court to take an administrative decision about formation of the larger bench as early as possible, so that the matters can be placed before such larger bench on the next date itself. Full stop. Over.